So Airman killed by M18 pistol. That's the Sig 320, one of the variants adopted by the military, which I believe, by the way, the military adopted it precisely because of the price point over alternatives like the Glock. Do you think there's a reason maybe Glock didn't drive the price point down as low as Sig? Could component quality have something to do with it? Tragic story here. That's a picture of a 320 in recoil, ejecting brass. Pretty good grip there, I have to say. Pretty good grip. Not perfect, but pretty good. The Air Force identified the airman killed by the discharge of a Sig Sauer M18 pistol as 21-year-old Brandon Lovan of Greenville, Kentucky, was on duty at an Air Force base in Cheyenne, Wyoming, when he was fatally shot by an M18 pistol. He served as a remote targeting engagement system operator, worked inside the weapons storage area while on duty. Described as an enthusiastic athlete and a young man with an exceptional sense of duty. America needs an infinite supply of people like this. He was such a selfless kid. His tragic death has since led the Air Force Global Strike Command to ban M18 handguns from use during an investigation and safety inspection of the firearms. A leaked July 21 memo called for the M18 to be pulled from use for all operational and training activities immediately and replaced by the M4 rifle, what we all think of as an AR-15 rifle. Of course, the M4 military variant would have a fully automatic function. Details about what occurred have not been released and remain unclear. What I'm hearing is he took the holster and gun off as a unit, put it on a table, and it discharged, and the round struck him in the chest and killed him. Over many years, the P320 has been beset with allegations of accidental discharges, which have led to numerous lawsuits and bans by law enforcement agencies. Sig Sauer has rejected all the allegations. In response to Lovin's death, Sig Sauer posted a statement on social media saying it would assist both the Air Force and the Army in answering questions about the incident. It's not going to bring this young man back to life, is it? Now they're sympathetic. And here is that statement. I'm not going to read the whole thing. Many channels on YouTube have covered it. They're taking the M18 off the line, and people who would have been issued the M18 pistol for military purposes will instead be issued the M4, and all the M18s have to be reviewed for safety. And this was a general issued this memorandum. And I just asked Rock, out of curiosity, what law enforcement agencies have banned the use of the Sig Sauer P320 pistol? Because I'd heard just incidentally that an agency here had banned it, an agency there had banned it. But I was really surprised at the length of this list of law enforcement agencies that have banned or restricted the use of the P320 due to concerns over unintentional discharges. ICE, U.S. Immigration and Customs, July 9th. And by the way, the death of this airman occurred just a couple days ago. Do they give the date here? Well, journalist, of course. So many of these are before the airman was killed. U.S. Immigration and Customs Enforcement telling its personnel to transition to the Glock 19 pistol. Hard to go wrong with the Glock 19 pistol, folks. U.S. Air Force Global Strike Command, this was after the airman was killed. Chicago Police Department, Milwaukee Police Department, Dallas Police Department, SEPTA in Pennsylvania, that's their transit police. I think they had a guy sit in a food court and his gun just went off in the holster. Washington State Criminal Justice Training Commission, Oregon Department of Public Safety, National Law Enforcement and Firearms Instructors Association, which is not a law enforcement agency, but it's a training organization for law enforcement. Burlington Police, I presume that's in Vermont. Kitsap County Sheriff's Office, Washington. Canadian, the Canucks are in it too. In addition, other law enforcement agencies, Alabama, Connecticut, Florida, Texas, Wisconsin. So it's a lot. And these are people, these are entities that are supposed to know something about guns and pistols in particular. And they're taking the P320 off the table as an option for their personnel because of these uncommanded discharge safety concerns. And them making this decision is a real thing, even if it were to turn out that there's nothing wrong with P320s. There's no engineering problem. There's no actual safety problem. There's other explanations for all these events, independent of any quality issue with 320, that Sig Sauer was right all along. Their guns are perfectly safe as a handgun can be. Even if all that's true, all these agencies have still taken the 320 off the table as an option. And that's going to create legal liability for anybody that does not do that moving forward, for reasons I'll explain in a moment. I also asked Grok, what prominent private firearms training schools have banned the use of Sig Sauer P320 pistols? Now, the list here is shorter, but the shortness is a bit misleading because there's really only a handful of really prominent civilian shooting schools, and some of them are listed here. But there's hundreds, there's maybe thousands of smaller, very credible civilian shooting schools. I'm not trying to diminish their quality. They're just smaller, and they tend to be more regionally known. And I've seen reports of scores of these banning the P320. But the big ones, the national level name recognition ones, Gunsight Academy, one of the oldest, most long-standing civilian self-defense shooting schools established by Jeff Cooper. And I've been trained by Jeff Cooper on the 1911 45 ACP pistol before we lost Jeff many years ago now. Gunsight Academy has banned the 320 from all courses. Limited exceptions for military and law enforcement, I guess, if they're still being issued it. Rangemaster, Tom Gibbons organization. And I've taught at Tom Gibbons at his Rangemaster school when he still had it in Memphis, Tennessee, and I've been to many of his Rangemaster annual events as an invited instructor. I think the world of Tom Gibbons and his lovely wife, Lynn Gibbons. A lot of truth comes out of Tom Gibbons when it comes to the use of firearms for self-defense. Rangemaster banned the P320 from their classes. The Complete Combatant, Suarez, Gabe Suarez, that's worth a whole show by itself. But anyway, he's listed here. Valor Tech, I have to confess I'm not familiar with. A Girl and a Gun Women's Shooting League. And I don't know how long it is before the big guys, USPSA and IDPA, ban the 320. I don't know if they've done that or they plan to do that. And there's a bunch of others. So others that are smaller that I'm quite familiar with. The Modern Samurai Project, Jedlinski, does a lot of red dot training courses. I've taken instruction from Jedlinski. He's banned them. Masad Ayub, who wrote the foreword to my book, the Masad Ayub Group, has been teaching self-defense with handguns for decades. I took his LFI 1 course in, I think, 1995 or 1996. Moss has banned the 320 from all his courses, and there's plenty of others. These bannings are all real things, even if it were to turn out that there's nothing wrong mechanically or safety-wise with the P320 pistol. Nothing wrong. And so, because we have to keep in mind that when we talk about legal liability, we're not really talking about reality. That's not what happens in the civil court process, because the civil court process involves human beings. It doesn't involve computers. So when there's a lawsuit over a gun, and there's been a lot of lawsuits over the 320s, by the way. Fred, let's talk about that for a moment. So I asked Grok also, how many lawsuits has Sig lost? So Sig is sued, right? Someone's carrying a 320, and somehow it goes off, and they say, the plaintiff says, it went off, not my fault. It went off because of some defect in the gun, and they sue Sig. Lots of these cases, maybe dozens of them, working their way through various civil courts, state level, federal level courts. In 2 of them, apparently, Sig has been compelled to pay out. A judgment came back. Here's a couple. So Robert Lang, a federal jury in Atlanta found Sig Sauer liable for defective design in the P320, awarded Robert Lang $2.35 million in damages after his holstered P320 discharged without a trigger pull, injuring him. So that's a couple million there. George Abrahams, a Philadelphia jury, that's a state level jury, obviously, awarded $11 million to U.S. Army veteran George Abrahams, concluding that Sig Sauer was liable because the P320 lacked an external safety, leading to an unintentional discharge while in his pocket. I mean, those of us who know guns, we hear about a gun in a pocket, we presume some other item in the pocket got inside the trigger guard and discharged the gun. But anyway, this guy got 11 million. Now, of course, the jury that decided liability here found liability on the part of Sig Sauer and awarded these millions of dollars. Do they know for an absolute fact that these injuries were caused by a defect in the 320? I mean, they weren't even physically present. They don't even know whether or not it's true that the gun discharged while in the holster in the Robert Lang case, or that the gun discharged because it didn't have a thumb safety. They don't know for a fact, but you don't have to know anything for a fact, especially in a civil liability case. The jury is tasked with deciding whether it was more likely than not, 51%. So the jury could believe there's a 49% probability that Sig Sauer was not responsible here. And they still have to find against Sig, because if they're 49% sure it wasn't Sig, they're 51% sure it was, and 51% is all that's required for liability. And then damages. Now, people who support Sig, I see them talking a lot about the fact that Sig has had lots of cases that they've won. It says Sig has won almost all these cases except for like these couple. And when I look at these cases, what I tend to see is settlements. So Sig settled the case. And normally when you settle a civil case, there's confidentiality agreements that are signed. So neither party can talk about why they settled or for how much they settled. Usually no one's admitting liability. It's just, hey, we're going to give you money to make this case go away. Now, a settlement doesn't mean that Sig did anything wrong. Settlements happen all the time where the person being sued says, listen, I don't think I did anything wrong, but I can settle this for $1 million, or I could spend $100 million proving I didn't do anything wrong. And maybe irrationally lose anyway, and then be on the hook for $200 million. So it just makes economic sense to pay the $1 million to make the case go away, even if you don't think you did anything wrong, even if there was nothing wrong with your product. So a settlement does not mean that Sig lost the case, or that that's an indication there's something wrong with their pistol. But it also is not a win by Sig. It's not a finding that there wasn't anything wrong with the pistol. All you can conclude from a settlement is that the person who sued, they also felt that receiving whatever, the $1 million, was sufficient for them not to have to go through the trouble of suing through the entire case and maybe not winning at the end. So a settlement is just an accommodation. It doesn't mean one thing or another. It doesn't mean one thing or another from a legal perspective. Of course, for people who are not lawyers, they'll look at settlements and they may well think, well, why would you settle if you think you didn't do anything wrong? Why wouldn't you fight it to the end to prove in court that your gun was safe? Another factor that has to be considered for everybody. Here's a case that just came out, and it was a finding of liability, a fault, I should say, on the part of Sig. 7/30/2025. That's yesterday, folks. United States District Court, District of Massachusetts. So this is a federal court. These two people sued Sig Sauer. And this is a jury verdict form. Did the plaintiff prove by a preponderance, 51%, of the evidence that Sig Sauer breached the implied warrant of merchantability by defectively designing the P320 pistol. The jury said, yep, we believe that. More likely than not, Sig marketed a defectively designed P320. Did the plaintiff prove by a preponderance of the evidence that Sig Sauer's defective design caused him injury? Yeah, we believe that too, the jury said. The pistol's defectively designed, and that defective design caused this plaintiff's injury. All right. Did the plaintiff prove by a preponderance of the evidence that the defendant, Sig Sauer, breached the implied warranty of merchantability by failing to give adequate warnings? This gun may kill you. On the 320 pistol. Yes, the jury says. Defectively designed pistol caused the injuries. Inadequate warnings by Sig. Inadequate warnings. Another one about, let's see. Did the inadequate warnings cause the injury? There, the jury said no. But here's the catch. So what do we have so far? We have the jury saying, yes, Sig misdesigned the 320. That poor design caused the injuries, and there was inadequate warnings. But then we get to the question of monetary damages. And what did the jury decide on monetary damages? Well, one thing that can influence monetary damages is the person being sued could do all kinds of things wrong. But if you contributed to whatever the damage was, you're responsible for that part of it. And in fact, you could be responsible for all of it. So let me give you an analogy. Someone designs a car, and the car has bad brakes. They just don't work very well. If they have to stop in an emergency, a driver in that car, and they slam on the brakes, it takes forever, an unreasonable, a reckless distance for that car to come to a stop. The car is just not safe. And then the car runs somebody over while the driver's braking hard on these crappy brakes. Runs somebody over, that person gets injured. They sue, and they convince a jury this car is made with bad brakes. Bad brakes. No question about it. The brakes are inadequate. But it also turns out that the person who got hit by the car literally threw themselves in front of the vehicle with the intent of being struck so they could bring a lawsuit. Well, then the jury might say, listen, the brakes are bad, but at the end of the day, you're the one who caused your own injury. You threw yourself in front of that car intentionally. So it wasn't really the bad brakes that caused your injury. The most proximate cause of your injury was your decision to throw yourself in front of the car. We're not going to give you money for that. That's on you. That could have happened with a car with good brakes. Right? So we get to that question here. Did Sig Sauer, the defendant, prove by a preponderance of the evidence that the plaintiff voluntarily and unreasonably used the P320 pistol knowing that it was defective and dangerous and was injured as a result? And the jury answered yes. This plaintiff knew the gun was defective and dangerous, and he used it anyway. And the use of that pistol is unreasonable. If you know it's defective and dangerous, your use of that gun is unreasonable. You are assuming the risk. I mean, that's a standard, well-established principle of civil law. If you don't know it's dangerous, if you believe, in part because there's an implied warranty of merchantability, people selling guns, there's an implied warranty that the gun's not unusually, recklessly unsafe. So if you don't know that and turns out the gun's unsafe, well, that's on the maker. But if you know the gun is unsafe and you use it anyway and you get injured, you've assumed that risk. That's on you. So when the jury answers yes to this, that the plaintiff voluntarily and unreasonably used a P320 knowing it was defective and dangerous, the amount of damages they got was nothing. Nothing for either of these plaintiffs. Why? Because they assumed the risk. Now, does the jury here really know if the gun's poorly designed? I mean, they're not mechanical engineers either. They're not gunsmiths. They probably don't know anything about guns except for what they heard in the courtroom. So they don't have any personal knowledge of these things. But in the courtroom, they were told stories. They were told a story by the plaintiffs, and they were told a story by Sig Sauer. And I'm sure everybody brought in expert witnesses who told stories from one side or the other to the jury. And the jury is going to come to a conclusion based on those stories. It doesn't really matter if the stories are true. It matters if the stories are convincing to the jury. A jury of 12 people, randomly selected from the community. The average IQ is defined at 100. So if the jury's average, that means half the jury had an IQ below 100. Are they really making decisions based on reason, critical thinking, or based on stories and how they feel about the stories? So even if you believe that Sig has done nothing wrong here, that the P320 is perfectly safe, imagine that you're carrying a 320 or handling a 320 or poking a 320 with a pencil eraser. And it discharges and it goes off and hits somebody, kills them, maims them. And you get sued. And you try to say, listen, it wasn't me. It was the gun. And then the plaintiffs bring up this. Well, were you unaware of all this? You didn't know all these law enforcement agencies, all these military branches? You didn't know that all of these people, all of these institutions with expertise in firearms in general, and the 320 in particular, had concluded it was inherently unsafe for use? You didn't know about all this? And maybe you didn't actually know. But should you have known? Don't you bear some responsibility for knowing this if you're going to be walking around with a deadly instrument? And if you are, and that knowledge is imputed to you, because if you didn't know, you should have known, and there's a lot of that in the law, do you become liable? Are you assuming liability for the bad things that happen because you chose that pistol? So you're not just assuming liability for physical risk to yourself, getting shot in the leg, getting killed when you put the gun on the table. If something goes wrong and someone else gets injured, you're assuming civil liability as well. You could lose everything you own. And that's true, even if it later turns out there's nothing wrong with the 320. That you could lose everything you own in a civil suit because the jury is convinced that there is something wrong with the 320, and you should have known something was wrong with the 320. And you disregarded that risk, and this damage resulted. And so you're responsible for it. And I haven't talked to these schools, the many training institutions that have banned the 320. But if I were their legal counsel, or if Tom Givens or Mas Ayub had called me and said, hey, what do you think I should do here? Do you think I should ban these 320s? I would tell them, listen, I'm just a lawyer. I don't tell people what to do. But you are assuming enormous liability, because there's no way these guys, as knowledgeable as they are, could credibly argue that they'd never heard anything about a problem with the 320. Obviously, they know. They wouldn't deny that they know. And you're assuming enormous liability by being aware of these claims, true or not, about the 320. If something goes wrong on your range and someone gets shot by a 320, now, maybe in reality, anytime you run a range, you know there's a risk. Someone on the line, they may put their trigger on the finger when they're not supposed to. They may be handling the gun loaded when they're not supposed to, right? Guns are dangerous. Things can happen. And maybe that's what's going on, and somebody gets shot unintentionally. Well, if it was that shooter's problem, contrary to instruction, he did something unsafe, that's his problem. But what's he likely to say? He's likely to say, oh, no, I never had my trigger on the finger. The 320 in my hand just went off by itself. And then a plaintiff's attorney comes in and says, you know what? Owner of the range, owner of this firearm school, We're going to sue you because you allowed that student to have a 320 on your range. He says the gun just went off. We know there's tons of reports of uncommanded discharges. We know there's tons of reports of uncommanded discharges with this make and model of pistol. And because you knew that and allowed the gun on your range anyway, you are liable for everything that happens with that gun. Now, does it have to be true that the gun discharged from an uncommanded discharge? No. Does it have to be true that the 320 discharged because of some defect as opposed to the handler pressing the trigger when he's not supposed to? No. All that has to happen for the liability and the damages to be incurred is for the jury to believe it's true. And they could believe it even if it's not actually true. By the way, this creates risk for you. Now, you may be thinking, hey, I have a 320, but I'm not going to carry it. I'm going to use it as a nightstand gun. I'm not going to carry it in a holster. I'll load it up, put it on my nightstand, maybe in a lockbox, whatever you feel is appropriate or your local laws require. And therefore, it's not a risk. I'll keep the muzzle pointed in a safe direction, all that kind of stuff. And imagine you're doing that, and you actually have a break-in in your home. Middle of the night, you hear glass breaking downstairs. You get your 320, you get a light on it. You go downstairs, turn the light on. Sure enough, there's a bad guy in your living room looking for stuff to steal. There's a broken window right there. Completely unambiguous about what's going on. This is a burglary in process. And the guy sees you with your gun and he's like, holy cow, I thought these people were on vacation. I definitely don't want to get shot. And he throws his hands up and he drops on his belly on the ground, all splayed out. He says, I give up, call the cops, arrest me. And you decide you're going to do that. But of course, it's a burglar. Burglaries are inherently dangerous, so you're going to keep him at gunpoint until the cops show up. So you're on your phone and you're holding him at gunpoint. You're telling the cops, yeah, the guy's on his belly. I don't see any weapons. I don't feel I'm in danger enough that I need to shoot him. So just get here, collect this guy. But I'm going to hold him at gunpoint because I got to keep myself and my family safe. Bam! And your gun goes off. Your gun goes off. And you're like, holy crap. I didn't even touch the trigger. All I did was change the angle of the gun slightly. And the gun goes off and it kills that guy. Kills that guy under circumstances where shooting him dead is not lawfully justified. And what are you going to say? You're going to say, I didn't shoot him on purpose. That would just be a murder. I didn't shoot him on purpose. The gun just went off. Maybe a prosecutor is going to say, yeah, let's see. Let's put this in front of a jury. Maybe it was manslaughter simply because you were pointing the gun at him. Maybe it was manslaughter because you were pointing what you knew or should have known was a gun that can just go off by itself. That's reckless conduct. You knew you were creating an unjustified risk of death, and death resulted. That's involuntary manslaughter. That's like a drunk driving homicide. That's a felony conviction. And you used the gun, good for 10 to 20 years in prison. Because you knew or should have known that gun was dangerous. Not to mention the civil liability, which is much the same as what we talked about with the ranges. So you get sued too. So not only do you end up in prison, but you lose everything. So you go to prison for 10 to 20 years and your wife and kids lose their home. All that has to happen is a criminal jury and a civil jury has to be convinced of those arguments. Do they have to be true in any absolute sense? No. The truth could be that the Sig Sauer P320 is a perfectly safe pistol, as safe as any pistol can be. But that truth does not save you from the liability. So again, I don't tell people what to do. I'm not telling any of you what to do. You want to buy a 320? You want to carry a 320? You want to keep a 320 in your nightstand? That's on you, man. You make your own decisions. I only try to help you make well-informed decisions. And part of being well-informed has to be having an understanding of the liability you're incurring by making use of that 320 in almost any way. And that liability is real and substantive and on your plate, regardless of the truth of the pistol. simply because of the reputation it's developed and the fact that criminal and civil juries are simply human beings who are being told stories in a courtroom and coming to a conclusion about whether or not they believe that story. Human beings whose average IQ is 100. So half of them statistically are below 100 IQ. Do you want to incur that liability? If you do, you do you, man. I personally would not want to incur that liability. I can't imagine anything that I'm going to do with the multiple 320s I own. I just don't know what to do with them. Apparently, the gun stores won't buy them back anymore, is what I'm hearing. Be nice if Sig bought them back. But if Sig buys them back, I mean, I imagine Sig has done the math, right? If we buy back every P320, I mean, do we know how many they've sold? Is it possible to know that? They've been selling them for what, a decade? And now they got the military contract recently. How many P320 pistols has Sig Sauer sold? So 500,000, over 400,000 just to the military. Hundreds of thousands to law enforcement. One of the top selling handguns in America. I mean, could it be millions? At what? An average of $600 a piece? And of course, some of the competitive type variants are a lot more costly than that. Yeah. So anyway, for the and I know there are Sig fanboys out there. I don't know why people get emotionally attached to guns, but to me, a gun is just an implement, just a tool. Either they're reliable or they're not. But to get emotionally attached to a brand, I would rethink that position. I mean, if Glock was having the same problems, I'd be saying the same thing about Glock or Smith and Wesson or and any of the handgun companies. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.